Be ready. Start. He may, agreeing with the conclusions arrived at by the police, accept the report and drop the proceedings. But before so doing, he shall give an opportunity of hearing to the complainant, or he may take cognizance under section 190(1) clause B and issue process straightway to the accused without being bound by the conclusions of the investigating agency, where he is satisfied that upon the facts discovered or unearthed by the police there is sufficient ground to proceed, or he may order further investigation if he is satisfied that the investigation was made in a perfunctory manner, or he may, without issuing process or dropping the proceedings, decide to take cognizance under section 190(1) clause A upon the original complaint or protest petition, treating the same as complaint, and proceed to act under sections 200 and 202 CRPC, and thereafter decide whether complaint should be dismissed or process should be issued. Although, in view of the law laid down by this court, order for further investigation could be passed by the learned magistrate, but in my opinion, the learned magistrate has not committed any illegality in not making order for further investigation and treating the protest petition of the applicant as complaint. The entire facts of the case are in the knowledge of the applicant, and he may lead evidence in the court of magistrate concerned to substantiate the allegations made by her against the accused in her first information report and protest petition submitted by her against the final report. This court has specifically held that the magistrate may, without issuing process or dropping the proceedings, decide to take cognizance under section 190(1) clause A upon the original complaint or protest petition, treating the same as complaint, and proceed to act under section 200 and 202 CRPC, and thereafter decide whether complaint should be dismissed or process should be issued. The learned magistrate in instant case has adopted the procedure laid down in clause 4th I bid. Therefore, for all these reasons, interference by this court in the impugned order is not warranted. Consequently, the application under section 482 CRPC, being devoid of merit, is hereby rejected. The learned magistrate concerned is directed to expedite the inquiry under section 200, 202 CRPC and pass suitable order under section 203 or 204 CRPC as the case may be. The office is directed to send a copy of this order to the magistrate concerned for necessary action. On April 27, 1994, this court, while noticing divergence of opinion expressed by different high courts on the scope of section 28A, issued notice to all the state governments and the central government, since the decision will have effect on all the governments, and directed them to appear and file their written arguments. Notice was also issued to the learned Solicitor General to assist the court. Though notices were served accordingly on all the state governments and the central government, only the central government and some of the state governments have entered appearance through their counsel. However, none has filed written arguments till date despite opportunity afforded therefore. It is contended for the state governments that Section 28A, since speaks of persons interested and aggrieved, a claimant who received compensation without protest becomes disentitled to make an application under Section 18 because of the second proviso to subsection 2 of the Section 31. He, being a non-protester, cannot be an aggrieved person. A claimant who receives compensation under protest but makes no application under Section 18 becomes a person aggrieved under Section 28A of the Act and is entitled to seek redetermination for higher compensation. The question of redetermination of compensation would arise only if an award under Section 11 had been made by the Land Acquisition Officer Collector after the Amendment Act had come into force, namely September 24, 1984. In other words, their contention was that Section 28A is prospective in operation and has no application to any award made by the collector LAO prior to the Amendment Act had come into force. It was also contended that such an application should be made within 3 months from the date of the award of the court, that is, civil court, on reference under Section 18 and note on each successive award or a decree in appeal. The limitation of 3 months should be computed from the date of the award of the civil court first in point of time, and that neither the subsequent award under Section 26 or the judgment or decree of the High Court under Section 54 or of this court does furnish any cause of action, nor does the limitation of 3 months under Section 28A start running from the later dates. When an appeal was filed by the state beneficiary against the award and decree of the civil court, the collector LAO has to await the decision of the High Court or this court before redetermining the compensation.